Hello, everybody. Thank you for joining us for this European Criminal Law Association seminar. So we are grateful to our speakers who have given up their time to be with us tonight. The session will firstly be focusing on recent developments in the use of diplomatic assurances. And we will be hearing from Anand, Doobay and from Asya, Mandzhukova, Stoyanova, who will both be speaking on that topic. Our third speaker is Dr. Andrea, and she will be speaking from an Irish perspective, but looking more broadly in relation to updates on Irish extradition. So I am not going to take up too much of your time. I'm going to firstly introduce our first speaker. So Anand qualified as a solicitor with Hogan Lovells and then was working at Peters & Peters, where he was a partner for many years before forming Boutique Law, where he deals with criminal and regulatory matters, including fraud, extradition, mutual legal assistance, red notices, corruption, sanctions, tax and money laundering, I think, just to name a few. He has been acted in numerous different capacities in relation to extradition proceedings. He's also advised a serving Prime Minister, a former Deputy Prime Minister, a Deputy Foreign Minister and 3 G20 governments, and been involved in a number of high profile and politically sensitive investigations and prosecutions in many countries around the world. He was also, as many of us will know, participated in the UK government's review of extradition arrangements, and the European Parliament also asked him to prepare an expert report on potential reforms to the European arrest warrant when the UK was a member of the EU. He's also consulted as an expert by Fair Trials, particularly on their report for Interpol. So I will hand over to Anand.
Thank you so much, Gemma, for that introduction. Whilst we are going to be talking about recent developments in diplomatic assurances, I'm actually going to go back a long way to start with. So I thought it might be useful just to sort of track the development of diplomatic assurances in extradition. So if we go back as far as the 1870 Extradition Act, there was a case in 1876 where basically there was a request to the UK, and the UK, in refusing the extradition, said, look, we're not satisfied that we can allow this extradition unless we have an assurance that if the person is sent to the United States, which was the country making the request, that this person is not going to be prosecuted for something other than the offence which is set out in the extradition request. And that's what's now called the specialty protection and is commonly known and commonly enforced. So you can see there are a very early example of a diplomatic assurance to say there is a protection which is built into extradition law, and we require from the country making the request an assurance that they are going to adhere to that protection. The next sort of big category of assurances which are used concern the death penalty. So the UK is obviously party to the Council of Europe Convention on Extradition, and that allows for the use of assurances where the death penalty is at risk. So if there is an offence which could carry the death penalty, given that the UK it doesn't allow for extradition to countries which impose the death penalty, the assurance can be given that even if the death penalty is imposed, it won't be carried out. And that's also a significant feature of our request with the US, because obviously the US does have the death penalty available to it. And again, the US-UK extradition treaty allows for an assurance to be given in those cases where there is a risk of the death penalty being imposed by the US. So, and that was tested in one of the earlier cases, the Suring case, where essentially representations were given that the death penalty wouldn't be imposed, or if it was imposed, then it wouldn't be carried out. But I think it's worth bearing in mind with those two categories. Firstly, the things that link them. One, they're lawful. So in the country that's going to receive the person who's being extradited, it would be ordinarily lawful to prosecute them for another offence that they're suspected of. And in the country where they're going to, in some instances, it would be lawful to impose a death penalty. So what you're getting is an assurance that the country won't do something that would otherwise be lawful in order to comply with a requirement of the UK in terms of its extradition arrangements. So then we move on to a more recent development in terms of assurances, where they have started to be used in relation to countries where there is a risk of torture. And one of the most well-known cases concerning this is the case of Chahal, where the UK was intending to deport Mr. Chahal to India, and as part of that process obtained an assurance. Now, the assurance was pretty bland. The assurance simply said, "We have noted your request to have a formal assurance to the effect that Mr. Chahal, were he to be deported to India, would enjoy the same legal protection as any other Indian citizen, and he would have no reason to expect to suffer mistreatment of any kind at the hand of the Indian authorities." So that is essentially just simply saying, well, we're not going to act unlawfully, because obviously nobody's allowed to be mistreated in India under Indian law. But the court, the European Court of Human Rights, was not satisfied with that assurance and said, whilst it didn't doubt the good faith of the Indian government, the assurances weren't thought to be effective, because the government, the monitoring body in India and the Indian courts haven't really dealt with the systemic use of torture in relation to those who are viewed as being against the government there. So you can see that that's a sort of extension of the use of assurances to where there is accepted to be a real risk that there might be a violation of somebody's rights in a way that would be unlawful in the country they're being sent to. This is sort of continued as a train of case law, and you can see in, for example, a case of Ismailov and Russia, but again, the European Court of Human Rights refers to Chahal, and also a case called Saudi and Italy, where there's real skepticism and real critique applied in relation to whether the assurances are sufficient, because the court starts from the presumption that there is an accepted risk, regardless of what the assurance says, that the assurances might be breached. We then move on to a case which was certainly very well known in the UK and has given rise to what's now the sort of mainstay test for how you assess assurances. And that's the case of Othman, also known as Abu Qatada. And in that case, the government wanted to deport Mr. Othman to Jordan. And in order to do so, they entered into negotiations with Jordan and arranged what's called a memorandum of understanding. And in this MOU, they went through and Jordan gave certain promises as to the treatment that would be afforded to Mr. Othman. And they were essentially that international human rights standards would be applied. And so again, there was obviously accepted to be a real risk that without those assurances, that treatment wouldn't be afforded. But there was pretty skeptical consideration of those assurances as part of the process, even though they were agreed ultimately to be sufficient. So once we have got to this part, you can sort of see that at this point, let me give you an example in terms of Othman. So the court, in considering it, said assurances were part of the matrix to be considered, but you still had to really look at whether there were substantial grounds for considering the applicant would face Article 3 non-compliant treatment. And that the abundance of international law material in that case supported the proposition that the assurances should be treated with skepticism, particularly if they're given where a country where inhuman treatment by state agents was endemic. So that was the sort of approach of the court in that case. In other cases where they were considering the use of torture. So what's happened since then is that the use of assurances has become much more widespread. And to take a quote from a case called Shankaram, the court basically said, look, extradition law has developed substantially since the late 1960s, and both the scale of extradition and immigration decision-making means that undertakings and assurances are not merely normal, but they're indispensable to the operation of English extradition law. And such undertakings are regularly taken into account and should be given whatever weight is appropriate on the facts of the particular case. But essentially, you can see the rationale. Because of the numbers of these cases, both in immigration and extradition terms that are being dealt with, the courts require them in order to effectively operate the extradition regime, essentially to be ordered to extradite people. So there is a growth in the use of diplomatic assurances as part of a growth in the number of extradition requests which have been made over time, because extradition requests have grown dramatically in the UK from a very low base of numbers in the tens up to the hundreds, now up to the thousands of requests that are dealt with each year. So once you've got this sort of expansion in the use, let's go back to the starting points in extradition law, which are that essentially there is a presumption of good faith. So if you have extradition arrangements with another country, the presumption is that country is acting in good faith when it makes its request, and therefore you can trust what it says in the request. There is also a rebuttable presumption that a country which is a member of the Council of Europe is going to uphold the European Convention on Human Rights. So again, you start from the presumption that if an ECHR member state makes a request, they're not going to violate Article 3 or Article 6 or Article 8. However, that presumption can be rebutted. And if you look at a specific example, the ECHR undertakes sort of what they call pilot judgment. So where they see that there are a number of similar complaints which are being made, for example, let's say in relation to prison conditions concerning Italy, they might group them together and they might then issue a pilot judgment, which shows that there is a systemic problem. So it's not confined to one prison or one person's treatment, but there is a systemic problem in terms of the adherence to, in that case, Article 3 within Italian prisons. So when you have that situation where the ECHR has said, well, look, there is a systemic problem, then the rebuttable presumption is rebutted. And then it's for the state that's making the request to satisfy the UK that in that particular case, the risk isn't going to eventuate. And they will normally do that by making a diplomatic assurance to say, well, look, we understand that the European Court of Human Rights has found this a systemic problem, but in this case, we can assure you that we will afford this person the treatment which they're entitled to so that it doesn't breach Article 3 of the European Convention on Human Rights. And the European Court of Human Rights has itself laid down, in this case of Othman that I referred to earlier, a list of criteria which courts are supposed to take into account when they assess diplomatic assurances and they decide what weight to give to them. And these criteria include some basic ones, whether the terms of the assurances have been disclosed, whether the assurances are specific or general or vague, whether the assurances have been given by somebody that can bind the state, whether they're by the central government, and if they are, whether local authorities can be expected to deal with them, whether the assurances concern treatment which is legal or illegal in the contracting state. So again, my comment earlier about torture, that's unlawful in the requesting state. Whether they've been given by a contracting state, i.e. a member of the European Convention on Human Rights, the length and strength of bilateral relations between the sending and receiving state, and very importantly, the state's record in abiding by similar assurances. And I'm going to come back to this because one would have thought that is probably the best indicator of whether a country is going to abide by its diplomatic assurances is whether it's done so in the past. And there was an argument which has been now conclusively resolved in the UK as to whether you could look at the adherence to diplomatic assurances for other countries. So if you're in the UK considering let's say an extradition request from Germany, can you also look at whether Germany's abided by assurance it's given to other countries? So an assurance it may have given to France or to Spain. And in the case of Zabolotny, the Supreme Court in the UK said yes. You know, if it's relevant to look at whether, in this example, Germany has abided by its earlier assurances to the UK in extradition cases, it's also relevant to look at whether Germany has abided by its assurances to other countries when making extradition requests. And then another very important factor that Othman sets out, whether there's an effective system of protection against torture. And for me, what is one of the most important things, whether the assurances can be objectively verified and monitored. Because it's all very well giving assurances, but actually in practice, they're designed to guard against a future risk. So what is really important is if extradition takes place, are they honored? So does it happen in practice after a person leaves? So that those are some of the factors, but you can see there's quite a lengthy list of factors that Othman says courts should take into account when they're looking at whether they should give weight to assurances which are provided as part of these extradition proceedings. They've been summarized, well, it's summarized, but they've sort of been given headlines in a particular case called Zagreb, where the court basically says, well, look, the terms of the assurance are such they must be fulfilled, and if they are fulfilled, the ill treatment won't occur. The assurances must be given in good faith. There must be a sound objective reason for believing the assurances will be fulfilled, and the fulfillment of the assurances must be capable of being verified. So that's the sort of encapsulation by the UK court of the criteria which is set out in Othman. So we've got now to the point where the court's considering them often, and they've got a set of criteria to consider them against. But when do we consider them? So basically, their assurances can be given at the start of the process, or they can be given partway through the process. And it's becoming more and more common that assurances will be considered at whatever stage in the process you are. So even if no assurance has been given in the first instance court, which then orders discharge of the person because of a fear of a risk, the appeal court will agree to consider the assurances which are put forward during the appeal stage of the process. We're also seeing the impact of developments within the EU. So whilst the UK is no longer part of the European arrest warrant scheme, when it was, there was a case called IALS, which indicated that if it was demonstrated there was a risk of ill treatment on return, then the requested state had to ask for further information, could give a time limit, but had to ask, and then had to assess that further information to see whether it removed the risk which had been identified. So though that sort of chain of case law has embedded itself within the UK and applies both in part 1, so EU requests, and also part 2. So the court will now, if it identifies a risk, will ordinarily go back to the requesting state and say, look, we've identified a risk, can you give us an assurance which will allow us to be sure that the risk is not going to happen in the future? So I mean, there are some pragmatic reasons for that. As part of the Assange case last year, the High Court said, well, look, if we don't allow the assurance to be admitted now, even though it wasn't put forward in the first instance case, the US can just make another request. So if we discharge this request, then tomorrow they can make a new request and they can put their assurance into the new request. So there is an element of pragmatism to the court's acceptance that they should accept requests whenever they're made. And there is also, I think, an element of a desire to make extradition work, which we saw from one of the quotes I read out earlier, in terms of the scheme has to sort of operate to extradite people. But sometimes you will find cases where judges' patience are tried too much, and they will draw a line and they will say, well, actually, you've had enough time to produce the assurance. And they do have, under their case management powers, the ability to sort of draw a guillotine and say, well, actually, I've given you all the opportunities you're going to have. I'm not going to admit it and I'm going to discharge. And the High Court has upheld that. So it's been challenged on occasion and the High Court said no. In specific cases, we are willing to agree that the first instance judge could draw a guillotine. And in one case, essentially, the case had concluded, the hearing had finished, the decision was about to be delivered, and the day before the decision was going to be delivered, an assurance was then given, and the judge said, it's too late. So there are instances where the court draws a case management line and says, well, look, we're not willing to allow the assurance to be taken into account because it's just too late. But ordinarily, that doesn't happen. And as I say, even on appeal, the court has now made very clear in Assange that it is willing to accept the use of assurances on appeals. So the other thing to sort of mention is that, as I said, to me, a very important factor is a history of abiding by assurances. But that appears to be becoming less and less important to courts. So courts appear to be more tolerant of what they call I'm going to quote it to you because I think it's an interesting thing. So they call it limited and specific breaches of assurances. So one would have thought it doesn't really matter how limited a breach is or how specific it is. It still illustrates a tendency within a particular country not to apply assurances the weight they should be given. But courts, I think, again, because of the systemic issue, are willing to overlook them on occasion and to come to the conclusion that even if there have been assurances which have been breached previously, that there there still can be weight given to later assurances which are provided. And you can sort of see that developing even with non-EU member states. So this obviously isn't the case now, but I'm going to give you the example of Russia. So at a time when the UK had just carried out a public inquiry into the death of Mr. Litvinenko in 2018, found that that had been at the direction of the FSB with the approval of the President of Russia, the High Court was still at that point willing to accept diplomatic assurances from the Russian Federation about the treatment which would be afforded to those who were extradited back to Russia. So you can see that we've moved from a very sort of skeptical approach to assurances where you have to give real scrutiny to it, to a point where even if the treatment which is going to be afforded is unlawful because it's in breach of, for example, Article 3, there seems to be more of a tolerance to give credence to what is said, even if there have been past breaches. The final point I want to return to is this issue of monitoring. So monitoring obviously is the way to ensure that assurances are in fact upheld. And also they would allow us to look back properly at what has happened in past cases and to see whether previous assurances have been breached when assessing whether new ones should be given weight to. And there was a select committee, the House of Lords did a report considering this, and they were very clear that they didn't believe that the arrangements for monitoring were sufficient. And that's because there aren't any. So once somebody is extradited, essentially the diplomatic assurance is an agreement between countries. So if they are breached, it is for the UK to complain about the breach of them. And there is no mechanism ordinarily to monitor them. So on occasion, they try and put in place ad hoc arrangements. So for example, they will say, oh, well, the British embassy can visit this person once they're extradited and monitor whether they're being ill-treated. But obviously that only works if the person's a British national. That requires resources. It requires the ability for the person to effectively be able to complain and not risk further mistreatment by complaining and being seen to complain. So there are lots of problems with the ad hoc nature of monitoring that currently occurs, and there is no system of monitoring. Despite this recommendation by the committee, the government in its response essentially said, well, we don't see there's a real problem here. So we're now left in a situation where we have widespread use of assurances to deal with situations where there's an accepted risk that if that person were to be extradited, they might be ill-treated in a way which is unlawful. But we don't really have courts which are very skeptical of the assurances provided, that are willing to allow them to be offered at any stage, essentially, where there's no real way to monitor what happens after the event once the person has left. So hopefully that gives us a sort of a historical overview and a sort of picture of where we are at the moment.
Thank you, Anand. I can already see that we do have some questions that have come into the Q&A chat. So hopefully most of you have been able to see that. So there's no live chat function, but there is a Q&A, and that comes through to the panel. We'll hold the questions until we've finished with the presentation, but please do feel free to pop those questions in as they come to you throughout the presentations. The way that they come in, it doesn't really disrupt the person who's speaking. So thank you, Anand. We're now going to move over to Asya, who has very kindly agreed to come to speak with us virtually today. And she is able to bring an EU perspective and the perspective from Bulgaria. So Asya, oh, hang on a second. Sorry. Sorry, Asya, your profile had just disappeared from me there for a second. So Asya graduated from the University of Sofia and registered as an attorney at law in Bulgaria in 2005 and has been specialising in criminal law for 15 years. She is the managing partner at Mandzhukova Shapov Petrov law firm in Sofia, Bulgaria, and she is a member of the Legal Experts Advisory Board of Fair Trials Europe. She has participated in numerous projects and written on matters in relation to EU criminal law from the perspective of Bulgarian law. She's presented expert statements and oral witness statements before Westminster Magistrates Court and the High Court on numerous EAW cases initiated by the Bulgarian authorities against Bulgarian citizens detained in the UK. She was a member of the working group of the Ministry of Justice on the legislative amendments to the Extradition Act on Extradition and the European Arrest Warrant, aiming to provide for dual-level judicial protection in the process of issuing and executing EAWs. Asya, I'll hand over to you.
Hello, everyone. Thank you for the introduction, Gemma. I hope you can see the screen I'm sharing. Today, I'm going to speak about diplomatic assurances across the EU, how effective and how reliable they are. I will start with the confession that I don't like and I don't trust diplomatic assurances, and I even think they are harmful. In my view, they're just an easy way for judicial authorities to release themselves from the responsibility to safeguard fundamental rights, hiding behind the mutual trust principle. My skepticism comes firstly and mainly by the fact that I come from a state where the rule of law is at such a high risk. And in my practice on EAW cases, I have seen so many officialized lies by various Bulgarian authorities, including in diplomatic assurances, that there is no way I can accept a principle that is based on the assumption that all member states have the same level of protection of democracy, fundamental rights, and the rule of law. Well, I'll give you the good examples from other member states, but in my view, they only prove that diplomatic assurances should not be treated as the exceptional and ultimate evidence for safeguarding fundamental rights. The second reason that I don't trust diplomatic assurances is that there is simply no follow-up on the compliance with the assurances. So it is impossible to say whether they actually are effective if no one controls their execution. As you will see from the examples I will give you, when a follow-up occurs, it is purely occasional and not a consequence of systemic efforts. After this confession, the second thing I have to underline is that assurances are subject to interstate communication. So there is no one place where you can find exhaustive statistical information on the requesting and provision of diplomatic assurances throughout Europe. So what I did was to acquire such statistical information from my own state, Bulgaria, make interviews with professionals in other member states, and also extract information from useful reports, such as the stream reports, which are publicly available, and in my view are a very useful source of general information on a country-by-country basis when you wish to prepare for a certain extradition case involving the relevant country. I'm giving you now the link to the stream reports, which relate to several countries. So apart from giving you the statistics for Bulgaria, I will demonstrate through example from various member states that the use and assessment of diplomatic assurances can vary a lot from state to state and even from court to court within the same state. And in some countries, they may also depend to a great extent on the general performance of the issuing country. So starting with Bulgaria, the Ministry of Justice kindly provided to me statistical information on the number of diplomatic assurances provided as an issuing state and received as an executing state in the last few years. We can never be sure on the absolute preciseness of this data because it has never been purposefully collected and systematized. Yet, based on the obligation of Bulgarian courts to send every judgment on EAWs to the Ministry of Justice, we can accept that it is relatively correct and, in any case, not surprisingly, demonstrating the uncritical attitude of Bulgarian courts towards other member states' requests. I hope you can see the table I'm sharing with you. You will see in it, can you see, Gemma, can you just confirm?
Yes, we can see that.
I'll turn to the PowerPoint now, and you'll see the first table below that there is information about 51 cases in 2020 and 66 cases in 2021, where Bulgarian courts have requested assurances by the issuing member states that Bulgarian citizens will be able to serve their sentences back in Bulgaria. But no such data is found about assurances on prison conditions for this or any other previous years. So to summarize, the Bulgarian courts do not require any diplomatic assurances on prison conditions, which is usually the most used diplomatic assurances. I asked the Ministry of Justice whether in 2021, post-Brexit, the number of assurances required by Bulgarian courts from the UK as an issuing state has increased due to Brexit. But despite the information that 6 new arrest warrant proceedings have been initiated by the request of the UK, still the answer is no data. This is not surprising at all. Bulgarian law doesn't provide for any proportionality assessment, so why would the court bother about prison conditions if the Bulgarian law doesn't bother about it? EU law, that would be too exotic to introduce and use. As most of you know, Bulgaria did not even have any form of judicial review of EAWs, which led to the judgment on case C648 of the 20th of the CJEU, for which I thank the English lawyers because they raised the question on two cases before the magistrates' court. And this case practically blocked the execution of Bulgarian EAWs across the EU and beyond in the UK. And Bulgaria still doesn't have a judicial review procedure. The draft bill is pending at the Ministry of Justice for nearly a year now, and we don't have a parliament to pass it. So the above statistical data shows the actual attitude of the Bulgarian courts towards these proceedings. They see them as a pure formality where they have sort of an administrative function to make sure all formal elements of the EAW are in place. I heard from my Italian colleague, Nicola Canestrini, that the same attitude is shared by the Italian lower courts, by the way. The fact that Bulgaria most probably did not make a single demand for guarantees on prison conditions only demonstrates attitude, but in my view, it does not make any practical difference because, as I said, these diplomatic guarantees guarantee nothing but the formal legality of the procedure. The Bulgarian Ministry of Justice admitted that they do not have a mechanism for a follow-up on requested and provided assurances from third member states. At the same time, you will see in the next table that in the past 5 years, Bulgaria has been requested to provide assurances on its prison conditions on a relatively regular basis. As you see, the UK is the absolute assurance requesting champion. And personally, I would credit UK defense lawyers on this because he always seems to raise this argument. A significant decrease of requested assurances is noted in 2021, including by the UK. And since nearly nothing has changed in prison conditions, my only explanation for this is that the CPT's last report, specifically on prison conditions in Bulgaria, is from 2015, and it kind of lost weight in comparison with the fantastic written assurances of the Ministry of Justice of Bulgaria, written throughout the last years. Do these assurances work? No. Prison conditions are not only about cell size and new window joinery. On a case of mine involving an EAW against a Bulgarian citizen in the Netherlands, the Dutch colleague who was defending him there told me that prison conditions in Bulgaria are still a topic for the court in Amsterdam. He said that their court is of the opinion that there is a general risk for persons being detained in Bulgaria to face the risk of inhumane or degrading treatment. Following the case law of the CJEU, Araniosi and Calderaro, the court will need to assess the individual risk in this specific case. Therefore, the Dutch prosecutor would ask the Bulgarian authorities for more information and the circumstances in the particular prison. My colleague was planning to ask me to write a report on prison conditions, but at the end, it turned out that the court found the Bulgarian diplomatic assurances on the cell size to be sufficient evidence and surrendered the Bulgarian citizen. Later on, the same young man was terrified and was begging me to get him out of the prison because he was bitten by bedbugs. He had the 4 square meters though. And this is not an isolated case. You know even better than me in your case law how breach of assurances on prison conditions were found on cases initiated by Bulgarian authorities. So we're now moving to Italy. I mentioned my colleague Nicola Canestrini, who is a brilliant defense lawyer and presenter. Make sure you invite him next time. He'll tell you very interesting stories on EWHC. He has many extradition cases, and he said that he's dealing with diplomatic assurances on a regular basis. He even notices increase of the request for diplomatic assurances, where most of them relate to prison conditions. Why? Because he always raises the question about fundamental rights for his clients, so the court is obliged to take this argument on and explore it. Is this necessarily a good tendency? Not really. Attorney Canestrini said something that is common for Bulgaria too. Lower courts see these cases as paperwork. If he brings the question about prison conditions and presents evidence, they will only go for a diplomatic assurance and not digging further. And because in Italy there is no tracking mechanism too, it all remains paperwork indeed. He even said that when it comes to the USA as a requesting state, they think the US system works perfectly fine, so there is no mutual but one-sided trust there. The good thing, he says, is that higher courts are more diligent and they often cancel the lower court's decisions and instruct them to make a thorough investigation on the raised issue and not simply rely on diplomatic assurances. Either his own statistics shows that most assurances on prison conditions are requested from Belgium and Greece, and on fair trial from Poland. On the balance, you might want to see this report for Italy by the Stream project, which sounds way more optimistic than my colleagues' experience. Moving on to the next country, which is Belgium. The Stream report on Belgium presents a case where in the period between 2013 and 2019, Spain issued a total of 4 EAWs against a person with the initials NGE, all of them reviewed by the Belgian court. 3 of the EAWs were rejected, as credit was given to the CPT's reports over the Spanish assurances, having also in mind the convicting judgments of the European Court of Human Rights for the so-called incomunicado, which means isolated, conditions in which Spain held prisoners who were accused of terrorism and who were connected with the Basque organization ETA. Finally, in 2019, the 4th EAW was successful and the Belgian court agreed to surrender the requested person. The court followed the decision of the European Court of Human Rights on the Castanho versus Belgium case in 2019, stating that there must be a dialogue between countries and a more thorough investigation in this process. So in 2020, the Belgian court took into account not only the diplomatic assurances on one side and the latest CPT report from 2017 on the other side, but also the fact that in the meantime, ETA was disarmed and dissoluted, while Spain also amended its imprisonment regime towards prisoners of this type, thus complying with the provisions of the EU Directive 48 of 2013. This whole case, in my view, is a good example on how courts must review and explore objections related to prison conditions or other risks of inhumane or degrading treatment or fundamental rights as a whole. The diplomatic assurances must comprise one evidence and not the most important one, or even worse, the only valid evidence where there is other contradicting evidence. I particularly like the position of the court on the said case by stating, first and foremost, there is never a presumption of respect for human rights, since the person object of an EAW has the right to demonstrate that there are serious reasons to fear a breach of human rights. The next country I made my survey on is Germany. You will see again a link to the stream report, which relates to Germany. It is presented with some statistical data. According to the most recent data available from the European Commission, Germany issues the most European arrest warrants per year, but also effectively surrenders the most persons pursuant to a receipt of an EAW. However, it is also Germany where the highest number of EAWs was refused to be executed by judicial authorities. 226 cases in 2018, 76 of which explicitly based on reference to fundamental rights. And you see case C220. You probably all know the case of the Hungarian citizen ML, who was subject to a European arrest warrant issued by the Hungarian state and reviewed by the German court, which led to the landmark case C220 of the 18th. Following the judgment of the CJEU on this case, in 2018, the German court surrendered ML based on a diplomatic assurance on prison conditions provided by Hungary. On a subsequent EAW against the same person issued in 2020, however, the German court found that previous diplomatic assurance was breached, and so was the mutual trust, thus leading the court to the conclusion that the second diplomatic assurance cannot be relied upon, and so the second EAW was not executed. I think this case is a perfect example supporting my general opinion about diplomatic assurances. The stream report, however, also points out various attitudes of the German court in terms of prison conditions, depending on the respective requesting country. Thus, it is stated on page 8 of the report that in particular, German courts did not see need for further analysis of prison conditions in Poland, referring to a lack of any indications of insufficient prison conditions, but held that additional information may be required for Belgium, that prison conditions had improved sufficiently in Lithuania, and that assurances given by Bulgaria are sufficient to mitigate any real risk. I wouldn't agree with this. The further execution of VAWs issued by Greek and in particular Romanian authorities has been stopped in a number of EAW cases due to prison conditions considerations. We can go further country by country, but I think this quick overview on these 4 countries demonstrate how different the approach could be in issuing, relying, and assessing diplomatic assurances in extradition proceedings. And now, finally, one more different case. I will share with you a recent extradition case for Bulgaria by the request of Russia for the extradition of a Russian citizen accused of tax crimes. On the part of the executive authorities, the Ministry of Justice, in its capacity as administrator of extradition requests, fulfilled its legal duty to administer this request to the prosecutor's office, but made an explicit reminder in the accompanying letter about the possibility of the prosecutor's office to refuse its processing following the decision of the Justice and Home Affairs Council in Brussels in early March, where EU member states agreed that because of Russia's invasion in Ukraine, they could ignore extradition requests made by Moscow. The prosecutor's office, unsurprisingly, decided to maintain the request. The Russian influence on the Bulgarian prosecutor's office and the courts in Varna is a public rumor. The district court allowed the extradition of the Russian citizen on my favorite ground, provided diplomatic assurances by the aggressor state, which denounced the European Convention of Human Rights. This shameful judgment produced a great media coverage and protests. Legal professionals started to talk about the legal side of the issue, and basically a scandal was formed. I saw an article on the topic in Euractiv where a judge was asked and told the media that she was not surprised by the decision of the court because, in her words, Bulgarian courts work on the basis of documents, not assumptions. This really demonstrates the way Bulgarian courts refer to extradition requests and EAWs. They really see it as paperwork. In her opinion, the documents provided by the Russian embassy charging the Russian citizen Auchin with tax evasion were sufficient to justify the extradition. When she was asked if the motives of Russia to get hold of Auchin were political, she repeated that Bulgarian courts do not work based on assumptions. I would say this is so Bulgaria. But the appellate court washed away the shame, cancelled the judgment of the district court, and rejected the extradition request on all grounds and risk you could think of, from political chasing to fair trial, prison conditions, etc. I'm willing to believe that this decision would be the same even if no scandal was formed and no protests were started. Thank you for the attention.
Asya, thank you very much for that presentation. That was really insightful, and there was a lot to take in there. And I can see that you shared a lot of that information as well. I'll try and get that in the chat function, the links that some people might want to have a look at during the next presentation. Just a reminder that as we move on to our final speaker, that please add any questions that you have for Anand or Asya in the Q&A function as we go on. We are now going to move on to hear from our final speaker, Dr. Andrea Ryan. Andrea is lecturer and co-director of the Centre for Crime, Justice and Victim Studies at the School of Law at the University of Limerick. And of course, many of you will know her as a long-standing committee member of ECLA representing the interests of Ireland. Her research expertise lie in the area of EU criminal justice, the European Convention of Human Rights, criminal evidence and comparative criminal procedure, criminal law and sentencing. She has written the book Towards a System of European Criminal Justice, The Problem of Admissibility of Evidence, and has acted as a national rapporteur for Ireland in a number of cross-jurisdictional studies, and has also been a project leader on a number of international and national projects. For example, a project on the Victims Directive, which was conducted by the Centre for European Constitutional Law. So I will now hand over to Dr. Ryan.
What I want to talk about is the surrender between Ireland and the UK and vice versa post-Brexit. And just the way I'm going to talk about it is basically, first of all, to look at how Ireland has incorporated the TCA, to look at the most frequently raised points of objection to surrender that are raised in Ireland, and then to make a comparison with those laws in the UK under the Extradition Act and the TCA, and to focus in on a number of those, specifically the absence of the prosecution decision, the proportionality, human rights, and then I'm going to look at some things that arise in Ireland in relation to other reasons that aren't in the framework decision, in relation to the doctrine of the abuse of process. And then I'm going to just look briefly at some cases that I was just searching for cases to see what was going on, if there was anything after the new arrangements had come into force, and I'm finding very, very little cases. So I don't know whether everybody's consenting or whether they're just not coming up. And then finally, I'm going to look at some recent developments in Ireland. So first of all, by way of context, we get a huge amount of surrenders between Ireland and England. So in the context, I'm not sure, oh yes, we have the slide. So in context, the number of the surrender orders that are executed by Ireland, the last report I had to go on was 2020. There was 24, and the only greater number was Poland, and just we have such a huge population of Poland. I think we've more Polish now than we have UK residents. Those numbers sent by Ireland in 2020 was 105, this is specifically to the UK, and made to Ireland was 35. So, and that was out of a total of 49. So the majority came from the UK in that situation. And then it was noted in that recent annual report that the UK remains the state with which Ireland has the greatest interaction. So then how we incorporated the trade agreement into the Irish law, on the next slide, we brought it in with the European Union, European Arrest Warrant Act 2003, Amendment Regulations 2021, and we had a previous transition period law, which was done by a statutory instrument in 2020. So now we're operating under these new regulations, and they've been enforced since March 2021. And they really don't set out a huge amount of change. You can see from the slide there, this is what we've basically put into the Irish European Arrest Warrant Act. Relevant agreement means in relation to European Arrest Warrant or in relation to a Trade and Cooperation Agreement arrest warrant. So the next, these are just some sections I've highlighted because this is where you see any changes, of which the European Arrest Warrant or the Trade and Cooperation Arrest Warrant, as the case may be. In the case of Trade and Cooperation Agreement arrest warrant, blah, blah, blah. So all that's basically done is make any consequential arrangements just to stick in the words Trade and Cooperation Arrest Warrant where it is required. I just put up the relevant sections of the Trade and Cooperation Agreement that I would be sort of referring to, or will be in the background in this. First of all, just the objective, which is set out now in Article 596, is to ensure that the extradition system is based on a mechanism of surrender pursuant to an arrest warrant. And then Article 597, which sets out the principle of proportionality. And then that is also repeated in Article 613. But I'm not going to spend any time on the actual TACA itself. So I want to change now to the way we do things and the obligation for surrender and the grounds for refusal that are set out in Ireland and the most frequently raised points of objection. So it's been made clear in the Tupikas case, well, it was actually in a Ciclosi case in Ireland, which referred to this case, that the execution of the European arrest warrant constitutes the rule, and the refusal to execute is intended to be an exception which must be interpreted strictly. So that was the European Court of Justice case in Tupikas. And the points that are most frequently raised in terms of objecting to the European arrest warrants here, in terms of objecting to the surrender, should I say, are Section 21A of our Act, the 2003 European Arrest Warrant Act, and that is basically the decision to charge and to try. We have Section 37 of the 2003 Act, which relates to the convention rights, and the constitutional rights under Section 37(1)(b). Correspondence arises frequently. It's almost like a standard, and generally doesn't succeed. Sometimes it does, but not really with England. And abuse of process is another ground which is frequently relied on in this jurisdiction. So what I want to do then is to look at the sort of similar things that come up in England, and this is based on the Extradition Act 2003, Section 11, which sets out the bars to extradition. and I've only included a few of them here that I'm going to talk about, the ones highlighted in yellow: the absence of a prosecution decision, extraneous considerations, and the passage of time. So looking first at the UK section 12A, the absence of a prosecution decision. The person's is barred, so the extradition is barred by reason of that it appears to the appropriate judge there are reasonable grounds for believing the competent authorities have not made a decision to charge, or have not made a decision to try, or have made neither of those decisions. And then it goes on, those representing the Category 1 territory do not prove that the competent authorities have made a decision to charge and a decision to try. By contrast, in Ireland, on the next slide, you can see section 21A of our Act. That provides that where it is issued in respect of a person, the High Court shall refuse, so it was a mandatory grant of refusal, shall refuse to surrender the person if it is satisfied that a decision has not been made to charge the person with and try him or her for that offence. But then it also contains a presumption that a decision has been made to charge and try, but it is a rebuttable presumption. You can see from the list of cases there that it has arisen in a very wide number of cases and has resulted in refusal in most of those cases that I have listed there. And the leading case is the case of Olsen, and that was by the Supreme Court on the next slide. There, the Supreme Court stressed that the surrender should only be refused where the court is satisfied that no decision has been made to charge or try that person. And that would be so where there is no intention to try the requested person at the time the warrant is issued. But then it clarified that the concept of decision in section 21A should be understood in the light of the intention referred to in section 10 of the 2003 Act and the purpose referred to in Article 1. And what those two relate to is section 10 provides where a judicial authority in an issuing state issues a European arrest warrant against whom that state intends to bring proceedings for an offence. So that intention is what they're saying that section 21 decision refers to, or by virtue of Article 1 of the framework decision, for the purposes of conducting a criminal prosecution or executing a sentence. So for the purposes of conducting a criminal prosecution, that again is how section 21 would be understood. In some cases, it was understood in that way. In other cases, it wasn't. And there's an awful lot of contradictory decisions in that area. It causes a huge amount of time in terms of the amount of questions that are sent from backwards and forwards from the court to try to ascertain once the person has raised that is trying to rebut the presumption with their own evidence. The court will then generally seek further information from the issuing state. So it takes up a huge amount of time. So that's section 21A, the prosecution decision. The next one then is human rights and proportionality. So the proportionality is set out in the 2003 Extradition Act in the UK. So where the judge is required to proceed, the judge must decide whether the extradition would be compatible with convention rights, and B, whether the extradition would be disproportionate. And then it lists all the specified matters that the judge should take into account in relation to the judging or relation to proportionality. And that includes the seriousness of the offence, the likely penalty, and the possibility of less coercive measures. So in Ireland, as far as proportionality is concerned, The proportionality was addressed, the only published decision in relation to the issuing of a warrant, which I could find. This was also actually in relation to that stream project that Asya was talking about a minute ago, because they're all done ex parte, so they're not published. But in that one published case, the court said that in principle, well, I'm saying, sorry, the principle, it has to be assessed by the issuing state, by the competent authority in the issuing country. So that's where proportionality is supposed to be looked at and assured. And in that case, they said that the purpose of the proportionality test is to assess whether the issue of the European arrest warrant is a justified measure in all the circumstances. There is a public interest in the prosecution of crime, even and sometimes especially when that requires cross-border cooperation. The use of international arrest warrants may not be justified where their effects on the requested person and the requested state are disproportionate to the ends that are to be achieved. So that's as far as the issuing state here. So when we're issuing the European arrest warrant, we have to assess the proportionality of the measure and whether indeed less coercive means could be used. But as far as the looking at proportionality in the execution of a warrant, so when we're being asked to execute the warrant, the leading case there is the case of Ostrovsky, which was relating to a surrender to Poland. And the High Court had said that it would represent a disproportionate interference with his fundamental rights, and particularly his right to liberty, etc. But so the High Court nonetheless certified a question to the Supreme Court to ask whether proportionality is a matter solely for consideration by the issuing judicial authority when deciding whether to issue it, or whether the High Court is entitled to consider proportionality when it is considering whether to surrender the respondent. The Chief Justice said that the question of whether or not the offence is trivial is not a matter for the High Court, and the High Court has no role to look at possible sentences which might be awarded in the issuing state, or to consider whether the sentence is proportionate. So Ostrovsky, basically, it absolutely confirms that there is no position for the High Court to assess proportionality at the executing of the European arrest warrant. In relation then to fundamental rights, because the section 21A that looks at persons not convicted, human rights and proportionality, so I'm throwing them both together. Fundamental rights, we have a clause in section 37 of the 2003 Act, and that has a fundamental rights clause, and it arises in nearly all the cases where there's an objection to surrender. The section 37 will be pleaded, and usually it's unsuccessful. It quite often relates to family rights. Often it will consider medical conditions of the applicant, it will consider delay and the detention conditions, and also we've had a number of cases in relation to the rule of law because of the amount of requests that we get from Poland. So section 4A of the 2003 Act says that it shall be presumed that the issuing state will comply with the requirements of the framework decision unless the contrary is shown. And on that basis, a person resisting surrender will have to satisfy the court that the issuing state is in fact not complying with its requirements to respect fundamental rights as per Article 1.3 of the framework decision. So they have to rebut the presumption. The burden rests on the respondent to adduce evidence that there were substantial grounds for believing that he would be at real risk of being exposed to a flagrant denial of justice. So that was held in the case of Rettinger back in 2010. family rights are frequently raised, and quite often they are, or generally speaking, they are they're not successful. So they are raised both under the Constitution and under the Convention. The leading case really on all these is the case of Minister for Justice and Equality and JAT number 2. And that had a whole lot of different things going on, which a lot of these cases would do in terms of the condition of either the applicant or their children, or things like that. We've also had cases in detention conditions, and generally they are unsuccessful. Again, once it's raised, the respondent will usually produce a number of reports that have been issued about that particular country. And then the court will follow up by seeking further information. Quite often then they're satisfied that things are better. And it's quite often that they refuse the argument and surrender the person, notwithstanding the detention conditions, with the exception of the case of George, which was successful. In relation to the rule of law, we started off all that rigmarole with Poland in the case of Selmer, which developed into the LM case. And so that was how that preliminary reference came about in the first place. And that, of course, was answered following the Arianosi case. And then more recently, there was another case, Orlowski, in 2021, and the Supreme Court in that case sent a preliminary reference to the European Court of Justice, basically asking whether the systemic deficiencies in the Polish system are such that they by themselves amount to a sufficient breach of the essence of the right to a fair trial, requiring the executing authority to refuse surrender. And they were basically pointing out to the fact that it was different to the LM case and the LNP case that followed, that because they wouldn't be able to, the respondent would not be able to identify what particular judge would be hearing their cases because they are randomly drawn. So basically it was an impossible test for them to pass. They would never be successful in order to actually prove the second part of the Arianosi test. But the result of that case, the preliminary reference, has only very recently come back, and that has basically repeated everything that it said in the earlier cases and stuck by its guns. And basically the appellants here, they have to be able to show that there is a real likelihood that the specific judge has in fact been appointed under the new system in Poland, and they haven't been able to establish that in their case the systemic deficiencies will have an impact on, a specific impact on them. So the court, the Supreme Court in that case, upheld or ordered the surrender of Orlowski back to Poland. And so there's been no change to that test as set out originally in LM or based on the Arianosi. In the Extradition Act 2003, you also have these what they call extraneous considerations, which are more or less repeated what we have in another part of our act and indeed in the framework decision. Passage of time and physical or mental condition. The reason I'm really just highlighting those is because these are the things you see, if you see in the next slide, that arise in the doctrine of abuse of process, which is frequently relied on in Ireland as an objection to surrender. It's arisen in a whole range of cases, and it quite often where the surrender has been ordered, or the court is following in their reasoning, and it's looking like, well, that argument fails and that argument fails, but then they bring the whole lot together, and in a big pot they end up with the abusive process. And in that case, it can be a successful ground. It was successful in the JAT case. But the courts, at the same time, they do look to see that or they highlight that they have, as they did in the Ciclosi case in 2021, that abusive process is not a ground for refusal listed in the framework directive, or decision it should be. So it was successful in the Bailey case, and it has been successful in quite a number of cases in terms of the refusal of the surrender being the final outcome. I also found it in an English case. I was just looking to see, is abusive process something that comes up in the English cases? I'm not sure whether I'm finding the right route to find all these English cases. This is through Bailey. I found a number of them. Cotton and the High Court, they did refer to the abusive process. So it was basically looking at hardship and difficulty and oppression. And that brings me back to that other slide that I had earlier on of the extraneous considerations, passage of time, and the physical or mental condition of the person, because these are really the sort of issues that have arisen in the Irish cases. But these, there may have been an argument of abusive process raised since this was answered in the case. So in that case, they suggested that it would be up to the Irish authorities to consider the abusive process in relation to the delay at the time of the trial. That was Cotton. Just then I went to looking for cases just to see what was happening. How were the Irish courts treating the English requests? How were the English courts treating the Irish requests? Specifically looking to see what had happened post the TACA coming into force. But I found precious few of them. A number of them were mainly all being dealt with under the framework decision, as opposed to so even these 2022 cases. So there was a case of Bullman in 2022. And the thing what I want to highlight here in these cases, I'm just going to slipping back up there to the Cotton case 2 slides back. At the end of that case, it said that apart from the fact that the Republic of Ireland is a member of the European Union and an adherent to the European Convention on Human Rights, this court places a very high degree of trust in the competence of the sense of justice which operates in the Irish judiciary. Coming back down to that slide on cases to Ireland, the Irish courts are more than capable of dealing with any proper concerns raised with regard to the fairness of proceedings. They said that there's no basis to conclude that the care that would be afforded to him in an Irish prison would be any worse than the care he'd received whilst on remand at Wandsworth. And I'm not sure really where they're coming from with that, because some of the Irish prisons are in terrible state. And then even allowing for the cumulative effect, blah, 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 the Republic of Ireland would be willing and able to provide appropriate medical care in these conditions. So just sort of highlighting those. In the case of Jess, I assume, and I am entitled to assume, that any decisions by the Irish court, either to put him on remand or to impose a prison sentence, would itself be consistent with his convention rights. And the district judge was correct to conclude that he would not receive, that there was no evidence that he would not receive appropriate medical care in prison in Ireland. All these requests were all granted, so there was no problem, there was no difficulty in terms of refusing the orders, ballots, BM. There was a whole list of hardships that were set out, which were actually quite similar to the case of JAT. But in this case, the district judge had granted the surrender, but the High Court in England refused it. They basically found that it was one of those very rare cases that all things balanced, that the surrender should be refused and the applicant was discharged. That was the only one I found where the order for surrender was discharged. Cases to Ireland are first, well, Ireland to UK, where we're trying to, somebody's been sought by the UK. The first one, I couldn't actually remember the name of the people, but the question, I think it was Connors, but anyway, there was a few of them where basically we're saying here that, well, we're not part of that withdrawal agreement. We didn't sign up to it. We didn't opt into it. But the question went to the European Court of Justice and it found, yes, it is binding on Ireland. So all the outstanding European arrest warrants were able to go ahead. That's just from SD. Another case, a recent case of Casey, that related to correspondence. That is something, again, that is quite frequently raised. And again, the court here was able to find correspondence with the offence that was being sought for there. And similarly in Hull, again, the surrender was ordered, no problem at all. So we haven't had much difficulty in terms of surrender requests being refused. Generally, Ireland does actually grant the surrender, and there doesn't seem to be a lot of problems coming from England to Ireland on the other hand. But we've just had quite recent developments in Ireland. Infringement proceedings were brought by the European Commission against Ireland in 2020, in October 2020. It did send it to a few other people as well. But it said that we had failed to comply with the mandatory time limits, and highlighted in red there, Ireland has provided additional grounds for refusal of a European arrest warrant, which affect judicial cross-border cooperation in criminal matters. So they sent the letter of formal notice. This was back in October 2020. There was a reasoned opinion sent somewhat later, but I don't know what was actually in that letter of formal notice, because they don't seem to publish them. If anybody knows any better, I would love to know, because I don't know what was actually in it. And the only way we can figure out what was in it is through the debates relating to the European Arrest Warrant Amendment Bill 2022, which was finally drawn up after those infringement proceedings were commenced. In that, the number of sections are repealed, specifically the ones where Ireland was granting refusals, and specifically section 21A. So while you still have that in England and Wales, you don't have it in, well, you won't have it in Ireland. It also repeals paragraph B of section 37(1), and that is where a person is pleading a breach of constitutional rights as opposed to the convention rights. That stays. And then another section, subsections 1 and 3 of section 39. So it also inserts failure to comply with the time periods shall not constitute a ground to surrender, because I think that was another thing that was going on as well. Now, the thing with that act is, or that bill, should I say, despite the fact that the infringement proceedings are at a very late stage and we should be in the court any old day now, it still hasn't been enacted. So we continue to be in breach, but when it is enacted, the section 21A argument will be gone, as will anyone under the constitutional rights. That will also be gone. Now, what is interesting here is, and because I can't see that letter, I'm not sure what happened with abusive process. Abusive process is not a ground in the Irish Act, it's not a ground in the framework decision, and it's coming purely from the common law. But without seeing the letter, we don't know whether that's actually has been picked up on as being a ground that should not be giving rise to refusals to surrender. So at the end of the day, the differences between the way we do it in Ireland, the way we do it in England, proportionality is the big difference. 21A is going to be gone. Fundamental rights, we do look under the convention, and they're usually more successful under the convention, and they're generally not successful under the constitution. So the repeal of that section shouldn't make too much difference. What is our likeness is our shared tradition of the common law system. And with that shared tradition, we also have the doctrine of the abusive process. So I don't know whether it's going to become a case of whether, as regards Ireland and England, the abusive process ground can be raised, whether it's, and then if it's an European arrest warrant for other states, well, we can't use abusive process, possibly. We don't know what the letter said. So whether it'll be different, whether it'll be easier in terms of operating an extradition system between Ireland and England than it will be between Ireland and the rest of the European member states, because of the fact that with them, we're in the minority. We don't have their civil law system, whereas with England and Wales, and Scotland, we have the common law tradition that is common to us both. So we'll probably just have to wait and see what cases arise and whether objections are not being raised and whether people are just consenting and they just can't find anything to base an objection on. I'm not sure whether it's going to be easier to go from Ireland to England or from England to Ireland. I also just highlighted some of the expressions of trust in the Irish system that are expressed by the English authorities in all those the cases that I looked at. And on that basis, it may be that even though there's more grounds for refusal in the UK, there would be on the other side of it the trust that is placed on the Irish system. So we'll just have to wait and see. I hope all that made sense. I think that's it.
Thank you, Andrea. That was a really helpful summary of everything which has been going on over the last few years, and some interesting comparisons between surrender between the UK and Ireland and vice versa. So we do have a few questions which have came in. Feel free to add any. The first question is about what monitoring mechanisms would you propose? So going back to looking at assurances, if we need to monitor assurances, how might we do that, and how might that be funded? Tony Wilson's asking that question.
So the EU is currently looking at this issue, but to give you a sort of an example of a comparator, one example is the Committee for the Prevention of Torture, which is obviously a Council of Europe committee, and you could envisage a similar body, or even the CPT having an expanded remit to deal with the monitoring of assurances for those people who've been extradited subject to assurances. You could also see, I mean, we heard this earlier on in one of the talks, having a register of assurances which have been given. That obviously doesn't monitor their adherence, but at least it gives you an information point in terms of seeing what assurances have been given by which countries. So I think that there are, and the funding of it, obviously the Council of Europe funds the Committee for the Prevention of Torture. So I think it requires some sort of supranational body, the EU, the Council of Europe, you know, the OSCE, something like that, which has a sufficient geographical reach and sufficient members, and has the ability to sort of set up the mechanism, because I think any individual country is going to struggle to do it.
And have the ability to be able to make that decision, in theory, that impartial decision that the assurance has been breached, because a register is helpful, but if we, you know, if it's not also letting states know when assurances have been breached, it's not as helpful. Asya, have you got anything that you would add with that? How would you fix the problem of monitoring diplomatic assurances?
Yes, sure. Surely the first step would be making proper registers of EAWs or extradition requests which do not exist, at least in Bulgaria, they do not exist. Then information, separate statistical information on number of assurances, type of assurances, specialty principle which has to be observed on each type of assurance. It's not difficult in Bulgaria at the moment. Courts have to provide all these decisions to the Ministry of Justice, and it's just sort of a little bit of paperwork to make those registries. Afterwards, it's really a good idea for this monitoring to be made by NGOs or any organizations which are funded and which are not the state authorities, because otherwise it will be like the countries controlling themselves. It should be separate. And I'm sure that when there is funding in place, many organizations would be willing to make such monitoring and annual reports and all sorts of this. Typical sources of information that we also use when we try to defend our clients.
Thank you. And I think, just in case, I'm not sure if everybody can see the answers to the questions, but you have really kindly typed an answer to a question. Marcus Vineyard asked, how are previous breaches of diplomatic assurances in a requesting state ascertained? And you answered that effectively it's about luck and how good your lawyer is. Is that, in short, how from your experience it works at the moment?
Absolutely. First, it has to be raised as an issue, and then really you need to find some track. Like my experiences with this report on finding breaches of the specialty principle, what I did, because there is no official information whatsoever. First, I searched the public sources of case law by word, specialties, specialty principle, whatever. I found all the cases, which are not many, and all these cases turned out to be referred to the court because a lawyer raised the hand and said, "Hey, there is a breach of the specialty principle." So the initiative always comes from the defense lawyer, and on all of these cases, a breach was found. So neither the prosecutor's office nor the court or any other authority actually monitors the compliance with the specialty principle. To my great regret, because this was a report which I provided on an extradition case before the magistrate's courts. To my regret, the court finally said, yes, breach of the specialty principle has been found in Bulgaria, but apparently the requested persons are now aware of this specialty principle, so their lawyer will be able to raise a hand and object if in their particular case this principle is breached. But to me, this is not efficient, because until the whole system moves, their rights can be infringed. They can be detained until the whole procedure is initiated.
Can I just add to that, Gemma? Because I think that comes back to the point you were mentioning before about the need to have somebody determine whether there's been a breach, because that's the real problem here in terms of proving previous violations, is that there isn't a body which does it. So you're either relying upon CPT reports, and the prosecution will say, well, these aren't people who had diplomatic assurances. These are just ordinary prisoners. So the fact they're being mistreated isn't relevant to us, because you need to find us someone who had a diplomatic assurance. And if you do try and find somebody who's already been extradited who complains their assurances weren't upheld, you're met with, well, they're a criminal. So how can we give any credibility to what they're saying? Because they may have their own interests, they may have their own axe to grind, they've been convicted of a crime. You have ludicrous cross-examination, which is, well, they tell you their cell was very small, but did they have a tape measure? How can they assure this court that their cell was, not the requisite the size as determined by the ECHR? So you have lots of issues about how to prove that there has been a previous violation. And then just to sort of finish on this comment, if you look at the case of Bulgaria, there's a specific case where basically the High Court finishes with, given that there have been lots of failures of the Bulgarian authorities to comply with assurances in the past, we must tell them that they've given assurances in this case, and that we think it's very important that they adhere to them, etc., etc., etc. And we don't find there's any risk. So, you end up with the ironic situation where even where the court is satisfied there have been lots of violations, and therefore they feel they need to make a real point to in this case, the Bulgarian authorities, you must honor these assurances. They still say we're happy to extradite.
Thank you. Another question that has come in that Anand, you might have some thoughts on, is about the impact of TACA for UK surrenders between the UK and the EU. Paul Arnold is asking, has there been, or do you foresee an effect of the TCA as regards the use of assurances between the UK and the EU, or do you think it's just the previous position continuing on?
I'm not sure there's going to be much of an effect. I mean, in theory, there could be, because obviously we've now removed the concept of mutual recognition. That's not what underlies the process and the mutual trust. But in practice, Andrea has already explained from the case law that that's not playing out in terms of how the courts are approaching it. So I'm not sure there's going to be much of a difference in terms of the way in which the process works. I mean, you theoretically could have more skeptical courts in the UK, but that would lead to more diplomatic assurances. So essentially, if the UK courts became more concerned about potential treatment after extradition to EU member states, they would essentially just ask for more diplomatic assurances. And I think that, again, to sort of just come back to two things Andrea said, we do have an abusive process jurisdiction, which applies to the extradition process itself, but it only applies to something you can't argue under the Act. So it has to be something separate to something which you could raise in any event under the 2003 Act. And Wandsworth is a very low bar. So whilst that case said that Irish prisoners could be expected to afford the same treatment as in Wandsworth, that isn't really saying anything.
Definitely not.
Asya, I don't know if you've got anything to add on that. It seemed that really, I think one of your core arguments is that you feel the way that the EU's failure to deal with diplomatic assurances and the direction that the courts have gone in risks mutual trust within EU criminal law. Am I right on that, or am I overstating that?
Sorry, can you repeat the question, because it was interrupting?
I was just asking whether you had any thoughts about, and I was talking about mutual trust and recognition from a UK perspective, and saying that largely that looks like it's continuing on under now that the UK is no longer a member state. But my question was more, it seems that one of your arguments is that the way in which all EU states and the EU court have been dealing with assurances risks mutual trust. Would you agree? Would you agree with that, or do you think that's overstating it?
Sorry, I'm not sure I get the core of your question. I was
so
saying
what I'm asking is that by allowing so many allowing diplomatic assurances to take place without any way of being able to check whether or not they have been breached or not. Do you think that undermines the principle of mutual trust between EU member states, that there's this high bar that's so difficult to get over because states are supposed to trust each other, and that's what's been holding states back from being able to properly deal with how we should dealing with assurances properly?
Yes, basically that's my opinion, because mutual trust overrides any idea of export, not any, but you see how differently courts in different states refer to it. In Bulgaria, it's mutual trust and nothing more. They don't care about anything else. They say it's mutual trust, we have to trust, that's it. In Germany, as you see in this particular case, which is a great example, they say, okay, mutual trust, but when we see a breach of the diplomatic assurance, which is practically the tool of mutual trust, we say, the German court said, mutual trust was breached, not only the diplomatic assurance, but also through the breach of diplomatic assurance, mutual trust was breached. So yes, I would agree with this.
Thank you. Okay, so I don't see any, I'm just going to double check if there's any other questions that have came in. So I think unless anybody's got anything else that they want to add, I'd just like to thank the three of you for giving up your evening to come and speak with us, and for such informative presentations.